rise to speak about the prosecution of barrister and former ACT Attorney-General Bernard Collaery in the ACT courts. The prosecution has proved very controversial, and that's for two reasons. Firstly, the matter involves 4 charges of contravening Section 39 of the Intelligence Services Act, that is, unauthorised communications of information relating to the Australian Secret Intelligence Services, and 1 count of conspiring to do so. The information in question relates to ISIS spying on Timor-Leste. Before and after a round of negotiations relating to the proposed maritime boundary between Timor-Leste and Australia took place in Dili on the 24th to the 27th of October 2004, Prime Minister Al-Colleary and Secretary of State Jose Teixeira outlined to their cabinet colleagues the negotiating position of Timor-Leste and the importance of the issue affecting their country. The Australian government arranged for these cabinet discussions to be clandestinely monitored by listening devices surreptitiously and unlawfully placed by ISIS in the Timor-Leste government cabinet meeting room. Working closely with elements of the Australian Embassy in Dili, ISIS recorded and transcribed the Timor government's internal deliberations. This enabled the Australian negotiating team to become aware of the private discussions of the Timor-Leste negotiating team and of its position in relation to various issues arising in connection with the negotiation of what became the 2006 treaty between Australia and Timor on certain maritime arrangements in the Timor Sea. It is scandalous and un-Australian that we would spy on a new, independent neighbour, the newest country in the world, an impoverished country, a country that gave great assistance to Australian forces in World War II, and in circumstances where we had agreed to negotiate with them in good faith. That someone may have called this immoral conduct out and is being prosecuted for blowing the whistle is unconscionable. Now, the second reason for the controversial nature of Mr Collaery's trial is that much, indeed almost all of the proceedings are taking place in strict secrecy. In this country we have a system of open justice. Someone passing by a court should be able to wander in and hear what the charges are, what evidence has been laid out by the prosecution, what the witnesses have to say, what the defence's evidence is, and what he or she may have to say. Importantly, an open court allows the public to keep an eye on the judge as well. Open courts go to the community's confidence in the courts, and the courts must be rooted in that confidence. Sadly, this trial is taking place behind closed doors, or at least it will, unless the full court of the ACT Supreme Court reverses the decision of Justice Mossop to close the court. So what's it all about? Australians do have a right to know. As mentioned in my opening remarks, in 2004, in the context of good faith negotiations, Australia spied on Timor-Leste. Can I tell you that's the first and dominant reason the Commonwealth want to close the court. They don't want to admit to the spying operation. Strangely, they do so in circumstances where the government of Timor have acted in a manner consistent with the operation having taken place. Those words I read at the start come from Timor-Leste's memorial in The Hague. They also do so in circumstances where the Australian government itself has responded to these proceedings with a team full of lawyers and negotiators. They've done so in circumstances where they've prosecuted a former ISIS officer for conspiracy to reveal a bugging operation in an affidavit that was tendered to the Timor-Leste and Australian Permanent Court of Arbitration proceedings. On that front, it's worth pointing out on the 2nd of April 2019, I asked the Secretary of the Attorney-General's Department, Chris Moriatis, whether he was aware of the allegations in respect of Australia spying on the negotiating team of the East Timorese. He replied, "I am aware of that. There's a criminal case in the ACT. I'm well aware of it." Now, interestingly, he made the link between the spying and the case in the ACT. And that's not unexpected, because it turns out that he was in the Australian negotiating team that would have been a recipient of the product of the bugging activity. I went on to ask him if I would be correct in presuming most criminal cases were not launched on the basis of a fictitious operation. He responded, "I would hope not." So the dominant reason for the secrecy is to avoid having to publicly acknowledge that the Australian government did the spying when everyone knows, it's just plain, that we did it, and it would be appropriate to acknowledge it for the healing of East Timor, and indeed so that Australians can rightfully ask why it was done. Indeed, I understand public interest rests in most cases in neither confirming or denying intelligence operations, but in this case it swings the other way. I would hope that well, what we know about what's happening right now is there are confidential briefs flowing around inside the court, and look, I'm going to give you some hints as to what they go to. The Commonwealth's position will be to say there was an operation, and behind closed doors they'll say there was an operation in East Timor, and that Mr Colleary disclosed it. That's what's going to be said. And Mr Colleary, by and large, will agree with that particular proposition that there was a spying operation. They will, I understand, contest whether the operation was lawful and whether the operation was lawfully initiated. These are two different questions, but indeed go to our national interest and indeed our moral constitution. I have no doubt that it was neither legal or initiated properly. The question doesn't involve national security sensitivities. It involves the sequence of events that led to the approval of the operation. Now, the way in which these operations are approved, I'm not telling you anything that's classified, it's in the Intelligence Services Act. There's a sequence, there's a proper process. Firstly, one of the ways in which to initiate one of these operations is for the executive, the collective, the National Security Cabinet to basically state a government requirement. That government requirement must centre around some pretty crucial principles, like it must be in our foreign relations interest, national security interest, or our economic interests. The reasonable question one can ask is, how can an executive government in a democracy ruled by law ever make an activity that would breach a solemn, signed undertaking to act in good faith, breach international law, cheat a fiduciary commercial partner and breach Australian criminal laws? A government requirement? It's likely that there's going to be difficulty in relation to that particular requirement because the Commonwealth has opposed, and this is available in open court, the request or the subpoenas for cabinet documents. But there is a second pathway. A minister can make a decision, particularly the foreign minister, in this case Mr Downer, can make a decision provided he is satisfied and has consulted with other relevant ministers. And they may have been Mr Howard, the Prime Minister, Mr Ruddock, the Attorney-General, Mr Hill, the Defence Minister, perhaps Mr Minchin, who was the Minister for Science, Industry and also assisting the Prime Minister. All of those ministers should have been asked, and there should be a written directive. And I understand there isn't, and that doesn't surprise me after my National Cabinet case, because the court was scathing as to the record-keeping of, in fact, the Commonwealth Government. So I suspect all of those people I've just named, all those ministers, will be on the subpoena list giving evidence. So we have specific controls placed on the intelligence services by this parliament, and my view is they haven't been followed. My view is that this operation was instituted by Mr Downer, not properly authorised, and done for the benefit of Woodside, which we've seen in evidence before the parliamentary committees on treaties. The Commonwealth Government has a view that whatever Woodside's interests are the national interests. So we need to watch this case. We need to press. I hope the court opens up the case, because the only thing really secret that's going to be talked about is, in fact, and it's not secret, is the fact that the operation took place. Disclosure of the basic fact that the operation was conducted and who did or did not authorise that action would go towards healing the rift between East Timor and Australia and satisfying
Senator
the Australian people.
Patrick